Welcome back to the Emily Show. And today we have some emergency motions that we need to talk about, like full emergency, because Michael Proctor. So much is popping off in the Karen Read multiverse that we have to talk about this emergency motion. And by the time this airs on Monday, there will have been an emergency court hearing. And the way that you're going to know about the result of that court hearing before I stream on Tuesday is by having the Lawnerd app. So make sure you have the Lawnerd app at lawnerd.app.com, where I keep you in the loop on all of the stuff that is popping off. And today it's a lot because we need to talk about something that happened in the federal case in April and talk about this emergency motion while looping in everything that's been happening on stream. So if you feel like you've been a little bit out of the loop, I've got you. If you followed every moment of this thing, I think there are some connections here that we haven't had a chance to talk about yet that I really want to talk about. And then the other things that we're going to be talked about on today's docket are just going to have to wait. We will get back to them soon. We've got a whole week ahead of streams that we will have a chance to get to stuff. But for today, back to Proctor and this emergency motion to please, Your Honor, pretty V, please don't make me do this deposition that's scheduled for Monday. So let's get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. Well. Last week, when I streamed the prior hearing with the judge asking all the attorneys in the Karen Read wrongful death case what was going on with discovery, I did not know how timely that would be because everything has popped off in the last few days, including late in the day on Friday when Michael Proctor filed an emergency motion to try to get out of his deposition scheduled for Monday, the day this airs, June 8th. And well, after that new lawsuit dropped on Thursday, which we covered on live stream, I'm going to summarize things here so we can get kind of an overview of where we're at in the multiverse. But after that dropped on Thursday, I was like, it's going to be real interesting. It's going to be real interesting to sit across from each other at deposition. And I think during that stream, I commented on that at least once, if not more, about how awkward Monday was going to be after this massive lawsuit dropped. And it's not a lawsuit against Michael Proctor. That's the lawsuit against Canton and Canton PD and Massachusetts state troopers. However, Proctor factors quite heavily in it as the text of his text messages and voice notes was heavily included in that lawsuit and is now out there for all to see. And we know that attorney Alan Jackson is in Massachusetts for this deposition. He has said as much publicly numerous times. And now Proctor is like, time out. I'm not ready to go to deposition just yet. Remember, depositions, we've seen similar things in criminal cases, but in the civil context, they are generally capped at either 6 or 8 hours and are an opportunity for the attorneys to ask a witness or a party questions under oath, have those all transcribed, videotaped, and then we see them at trial. The most we've seen depo videos really come in trial is in the Depp v. Heard case, where you saw edited depositions coming in. The reason those are edited is because at a deposition, an attorney can make an objection and then the party still answers and then you fight it out down the road. But I wonder if Proctor has some other concerns with what might be asked at the deposition. But this goes all the way back till at least April when we saw Proctor start asking about needing to get ready for his deposition. So let's do a quick overview road so far of where we're at in the multiverse, and then we're going to look at the federal case, then this emergency motion that was filed late in the day on Friday. Because when we back up, we've got to remember that the Karen Read, as we go through this docketed multiverse, the Karen Read wrongful death case in the civil realm was filed first. That was filed by the O'Keefe's kind of et al. Against Karen Read, the Waterfall, and C.F. McCarthy's. And a lot of the discussion in this case, litigation in this case, is happening under the umbrella of that case. Early on, Karen Read's attorneys had said, hey, in our defense of this wrongful death case that we are not at fault for the wrongful death. We also need to sue all these other people, and we're going to bring this in. And the judge was like, you're going to do what now? You're going to bring everybody else into this case? That's going to derail this wrongful death case for a substantial amount of time. And the wrongful death case was stayed for a period of time as to Karen Read. That was filed back in August 2024. And then as to Karen Read was stayed until the criminal proceedings were done, which is coming up on a year ago now. So with regard to Karen Read, she has not been active in this case as long as the other parties, which is the plaintiffs and the other defendants, the Barrs, CF McCarthy's, and the Waterfall. And we've gone over all of that. Then we had Karen Read suing the defendants, the House defendants, the McCabe's, the Alberts, Higgins, Proctor, Tully, Buchanan. That was filed in November of 2025 and then removed to federal court. It was filed locally. Then it was kicked out to federal court. So that's now the federal case, or the Karen Read sues everybody case. Then we saw those same House defendants sue Karen Read and Aiden Carney, aka Turtle Boy, in a defamation case that is now in state court. And then Karen Read sued Canton and MSP, Massachusetts State Police, in a different local action, which state court action, on Thursday, June 4th, 2026. So the litigation we have seen in now the multiverse of lawsuits are mostly happening in the wrongful death suit, though we have also covered litigation happening in a variety of criminal cases with regard to the Proctor et al. Discovery, because the fight over Proctor's phones has been heated at times, and it's going beyond the fight for just the discovery that the feds had when they, or if they are still, investigating whatever was going on in the Read case and the limited subsect of Proctor's phone. It has always been my understanding that Proctor's phone that was turned over in the course of Karen Read's criminal case was information that came from his work phone, not necessarily his personal phone, but there may have been personal phone stuff there as well. And it might have been the download of both the personal phone and the work phone, which is where some of those horrific text messages came from. But there were group texts that seemed to be work group texts, though work group texts can happen on a personal phone. Don't do that, though. In the words of The Offspring, keep that shit separated. Emily, that's not the lyric. I know. Work phone, personal phone, keep them separated. But that was a limited amount of discovery that was turned over during the course of Karen Read's criminal case. And then there was a full extraction of Proctor's personal phone. And the Proctor personal phone extraction, his lawyer who was representing him, remember, he had gotten terminated and then he was fighting his termination, and we're like, they're just texts and nobody gets fired for text messages. And it's unfair that he was essentially the victim of, not my words, the victim of a political and public outcry. And so he was just scapegoated and terminated, and they're just texts and nobody gets terminated for text, blah, 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 blah. So that was going through civil service, and we had watched some of those hearings together. And then at the 11th hour, as Proctor's getting ready for his final hearings, because in those hearings he had complained that he hadn't gotten discovery in a timely fashion from the Norfolk District Attorney's Office and MSP and others. Oh no. And he was on the eve of his part of his termination civil service hearings. And all of a sudden, he dropped his appeal, his civil service appeal, and the lawyers provided by the police officer union dropped him. Emily, what happened to make things change so quickly? The prosecution from the Norfolk DA's office said, hey, everybody, so you said there wasn't going to be any information because Proctor had lost a phone and then gotten a new phone. There were 3 phones that had been rehomed, and Proctor's lawyer was like, yeah, you can download the phone, but you're not going to get anything because it auto deletes. And there were multiple phones that have now gone through since that time. And then the prosecution came in and was like, so we can't disclose what we got yet because we haven't had time to go through it because it's so much. It's like thousands on tens of thousands on possibly hundreds of thousands of texts, videos, emails, because they got the iCloud account that went back to at least 2013. And so there's not going to be anything there was in fact, everything was there. And Proctor dropped his civil service appeal. His lawyers dropped him. And then we all went, oh boy, what is going to be unearthed from all of this? And we saw that last week on Thursday, some of what has been unearthed from all of that, including the other officer from Canton PD that had been named in a lot of this and had been placed on administrative leave up until last week when he was allowed to resign. So former Sergeant Sean Good is no longer with Canton PD, though the investigation, it's my understanding from their public statement, remains ongoing. So where does that put us now? Well, we now have seen what some of those text message concern. And while some of them might not be work related, some of them very, very clearly are. And I imagine Proctor would be confronted by some of that during his deposition scheduled for Monday. But this isn't a discovery issue at this point, as I see it, because what they're talking about is Proctor's phone. Proctor has his phone. He has his iCloud. This is information that is his, your words, your texts, your emails, your voice memos. You should still have access to it unless, could it be, and this is purely my pondering and speculation, could it be that after that iCloud was discovered, he maybe no longer has access to it? And that's why it's been so difficult for him to prepare for his deposition. One can't know, but what we do know is that in the federal case, Proctor started asking the court for discovery. Let's take a look at that real quick. Yes, we covered this on stream, but I hope that it's helpful to go back and give an overview of where we started seeing some rumblings about Proctor not being able to prepare adequately for his deposition, because the filing Friday isn't the first time we've seen this. And I think for some of you, you might not have caught this component of it going back to April. So hopefully, well, it's illuminating. Let's take a look. This is the memorandum of law. Defendant Michael Proctor's memorandum of law in support of his motion to conduct limited discovery to third parties prior to the court's establishment of a Rule 16.1 and Rule 26F conferences. This was filed on April 10th, 2026. What is Proctor asking for? He's asking, citing the precedent of Pretty v. Please, can you allow me as a defendant in this case to have discovery before discovery even opens? Discovery in this case was not at that time ongoing. Discovery hadn't even opened. This was too early. And he is saying that he needs the court to allow him to serve the keepers of records subpoenas for the Norfolk DA's office and the Canton Police Department. So he's like, hey, I need to get discovery from Norfolk County DA's and Canton PD. And to get a subpoena, you need to be involved in a case to get a subpoena. And he's asking the federal court to give him the power of Grayskull, no, the power of the court, to go serve those subpoenas to start to get documents for himself. He says that good cause exists to sidestep the established timelines, protocols, and rules because he is, listen to what he says here, because he is scheduled to be deposed as a witness on June 8th, 2026 in a parallel case pending in Plymouth Superior Court. That's the wrongful death case. And he represents, quote, plaintiff's counsel, who represents Miss Reed, has refused to provide Proctor with sufficient material with which to prepare for that deposition. Oh, sir. But But Your Honor, Karen Reed's attorneys won't give me the documents that I think I want to prepare for my deposition. They won't give me discovery. Maybe it's in one of your files with the videos from the Sally port. Oh no, we can't get our discovery. Yeah, it must be real frustrating when you ask for discovery and can't get discovery. Right. So Proctor was upset, or at least thought it was good cause that the court sidestepped the timelines to give him special discovery because Karen Reed's attorneys wouldn't give him the discovery for which to prepare his deposition. What discovery is that? His written police reports, I imagine, his files, other work things that he no longer has access to. However, that's a bummer right there. So he was asking to please allow this to go through so he could have sufficient material to prepare for his deposition. Karen Reed's attorneys had some thoughts about that. Let's take a look at the opposition before we look real quick at what the court did, because I think this foundation matters when looking at now him running up to the Friday before this deposition, all of a sudden saying, I can't attend my deposition. I have not had time to prepare. He started asking for more time to prepare and more information to prepare back in April. This is not new. Filed on April 13th, 2026 is Karen Reed's opposition to defendant Michael Proctor's motion to conduct limited discovery. Reed's attorneys say that Proctor does not point to any case, statute, rule, or other authorities supporting this request because there is none. Excuse me, counsel. He is trying to cite the newly established precedent of Pretty v. Please. It is in the same body of case law as Takesy v. Backsies and Fuck Around v. Find Out. It is the same body of work that we are looking at for this request. It is very much under the precedent of, Your Honor, Pretty v. Please. But I love that they very clearly point out he cites to no authority because there is none. If Proctor truly believed he had any right as a non-party deponent in a civil case in a state superior court to discovery of or access to any of these documents, he would have sought it in such court. He is in the federal court asking for subpoenas to go get information that is discovery that he wants to prepare for a deposition in the state court wrongful death case. They go on to say that apparently, recognizing he does not have a right to any of those documents, he instead asked this court to assist him in circumventing the state court rules. This court should not do so and should deny Proctor's motion. Respectfully submitted through Karen Reed's attorneys on April 13th. Let's look at what the court did. Emily, are you going to pull up a docketed item? No, because the court didn't even write out this ruling. It was a note on the court's docket, not a written ruling. That's where the court's at on this one. You can see that the court, and I love that when the court does things, they are in a different color. This is on April 23rd, 2026. We're looking at the official docket. As I said, they are referencing docket number 66. That is the notice of motion. And then the motion pleadings were docketed under 67, but this is the docket. Chief District Judge Denise J. Casper, electronic order. No, not a written order, an electronic order note to the docket. Entered regarding 66, motion to conduct limited discovery to third parties prior to the court's establishment of Rule 16.1 and Rule 26 conferences, having considered the motion of defendant Mr. Proctor to conduct limited discovery prior to the scheduling conferences in this matter, and the plaintiff's opposition. The court denies the motion. Denied. It's not even worth the court's energy to write beyond a docketed ruling. Just immediately denied. No discovery for you, Michael Proctor. But keep in mind that the court denied that back on April 23rd, 2026. And then we get to Friday, back in state court, back in front of the judge that we have been watching tell the attorneys for hearing after hearing now, how many depositions are done? How are we doing on discovery? What are we doing this evening? Why are we not doing depositions? How's your day, everybody? You doing any depos tomorrow? How many depos are in the books? How many have been noticed? How many have been scheduled? Why aren't you getting them done? Can we get them done faster? Anything I can do to help y'all get your depos done. And in fact, in the last hearing that we watched this week, the judge said, well, is there anything I can do to help you move this along? Because inevitably you will be back here before the court asking for an extension of time. And at that time, then we can talk about who's rescheduled which depot and who did what to whom with what. But the court made it very clear that they were agitated with all of the lawyers, and they couldn't understand why with so many attorneys, this wasn't getting done. And in fact, the hearing we watched just before that, a few weeks ago, the court said, I've counted up the number of lawyers in this case. And there are so many lawyers. And I just can't for the life of me figure out why discovery is going so slow. Can we please get this moving? And he gave a whole soliloquy to the attorneys about, I thought to myself, is it that they just don't know? No, it can't be that, because these are such experienced attorneys and there are so many of them. He had a whole worked out soliloquy for them. Since that, more than a month ago, there has been one additional deposition completed. These have moved incredibly slowly. And so on Friday, Proctor's lawyers file this emergency motion. Oh boy. Taking a look at docket item 108, filed June 5th, 2026. It's stamped at 2:10 p.m. in the Plymouth Court, emergency motion for protective order. This is in the wrongful death case. Non-party Michael Proctor hereby moves this honorable court for a protective order as to his deposition presently scheduled for June 8th, 2026. This motion is supported by ample good cause as set forth below. I mean, so say you, but this is the Friday afternoon before the deposition in front of a judge that has already told all of the lawyers exactly how he feels about the delay here, including, why can't y'all just get this done? They say Mr. Proctor is not a party to this matter. He is, at best, a mere fact witness. Keeping in mind, in the wrongful death case, Karen Reed's entire defense is that they framed her, so sure, he is a mere fact witness. Although Miss Reed has litigated this case extensively in the media, to the best of the Understein's knowledge, only 3 depositions have been taken in this case. What does this have to do with anything? To the best of the Undersigned's knowledge, only 3 depositions have taken place. Well, I think there was some variance between 3 and or 4, but that doesn't make it better that this one's getting delayed. It's just going to make the court more pissed off. We watched the hearing. Miss Reed's desired litigation strategy aside, are we in a position to really be throwing this much shade in a filing if you're Proctor's lawyer? I mean, groveling to the court seems like a better strategy than like, but Your Honor, they suck. Meh. What is this? Quote, Miss Reed's desired litigation strategy aside, Mr. Proctor will be produced for his deposition. But the previously agreed upon date of June 8th is no longer workable due to a variety of circumstances, as described further. Due to a variety of circumstances. Would those circumstances be named Alan Jackson? I'm just curious. What are the circumstances here? The stress of the additional lawsuit being filed. He's not a named party in that lawsuit, so he doesn't have to worry about that lawsuit. I'm sure he's very worried about it, but he's not a party to a new lawsuit. He will be produced for his deposition, but just not on June 8th. it's no longer workable due to a variety of circumstances as described further herein. Let's see if that's true. Given Ms. Reed's unwillingness to accommodate a requested scheduling change and representations that she intends to go forward with the deposition, Mr. Proctor hereby moves for a protective order on an emergency basis, footnote 1. Can you imagine the conversations between Reed's team and Proctor's team where they're like, hey, care to reschedule this deposition? After the judge was getting after all of the attorneys, including Reed's attorneys, for WTF haven't more depots taken place? I don't imagine they explained that as briefly as, I'm sorry, do you know how mad the judge is about this? I imagine the language was, we are disinclined to acquiesce to that request. When did they even have this conversation? Was it Thursday or was it Friday morning? I would be so curious to see when this went down, because I can't imagine they asked for this on Wednesday, because if they asked on Wednesday, wouldn't they have filed this then on Thursday? They didn't file this until late in the day Friday. So did this happen early in the day Friday? Can you imagine on Friday being like, hey, so we're going to need to reschedule? Karen Reed's attorneys being like, sure, Jan, that's not happening. Footnote 1 says that pursuant to Superior Court Rule 9A-D1, the provisions of Superior Court Rule 9A do not apply to emergency motions as further noted below, and as it pertains to Mr. Proctor's personal circumstances, the undersigned was only recently made aware of the circumstances necessitating a continuance of the deposition. Emily, English, not lawyer. They're saying they don't have to have a 9A conference. They're saying because it's an emergency motion, they can just file the motion without having to have a conversation with the other side. And they also say that as it pertains to Proctor's personal circumstances, the lawyer was only recently made aware of the circumstances necessitating a continuance of the deposition. So what has happened to make Proctor now, because they don't say he's unavailable. They do not say he's unavailable. They say that there are circumstances necessitating a continuance. But I wonder if by the time we get to this on Monday, Proctor is going to be, in fact, unavailable. And I wondered about that out loud in the Laundered Lounge discussion, where I wonder if Proctor has decided to make himself unavailable. We'll see what happens on Monday. But I wonder if this is going to go from circumstances to unavailability, because that's not what they're saying now. They're saying this is a scheduling. They're not saying he's unavailable. But I wonder if by Monday that will change. They go on to say that the court is no doubt familiar with the matter, so Mr. Proctor will be brief. On or about January 23rd, 2026, counsel for Mr. Proctor accepted service of a deposition subpoena scheduling Proctor's deposition for April 21st, 2026 at 10 a.m. On March 25th, counsel for Ms. Reed indicated the need to reschedule Proctor's deposition due to a scheduling conflict and a judge refusing to accommodate the date. Thereafter, counsel for Ms. Reed and Proctor worked to reschedule Proctor's deposition. Here's a key to that. Listen, they jointly rescheduled the deposition. The attorneys, including Proctor, picked the date of June 8th. On April 3rd, counsel for Proctor accepted service of a deposition subpoena scheduling Proctor's deposition for June 8th. So on April 3rd, they agreed to the rescheduling, but they have known that he was going to be deposed in this case. I mean, since the case was filed, you know you're going to be deposed, but they had formally known since January 23rd that they will be deposed. Of course, the undersigned advised counsel for Ms. Reed of a scheduling conflict on June 5th. Emily, just keep reading. So they told Ms. Reed's team Friday. That's not enough time. Should have just kept reading. The underside advised counsel for Ms. Reed of the scheduling conflict on June 5th, 2026. Counsel for Ms. Reed indicated that Ms. Reed would not agree to reschedule Proctor's deposition. Friday. They told them Friday, after the suit was filed on Thursday. What an interesting quirk of timing. Because if this was regarding not getting discovery in the federal case, they've known that since the end of April. So what could it be now? Other than that other lawsuit. They go on to say, counsel for Ms. Reed indicated that they were disinclined to acquiesce to their request. And then the argument is that, hey, the courts are allowed to do this. So they go through their argument saying that the courts are able to allow for a rescheduling. And they say that good cause exists for allowing this motion due to 1, existing practice and trial obligations of Mr. Proctor's counsel, but my lawyer's busy. 2, Mr. Proctor's personal circumstances. 3, the lack of any cognizable prejudice to Ms. Reed in rescheduling the deposition, except for the expenses already outlaid and the preparation that's already undertaken and the wrath of the court that more depots aren't done, but sure, it doesn't impact her at all. First, counsel for Mr. Proctor were each scheduled to try 3 separate cases during the month of June. 2, which ultimately did not go forward. Okay, so you didn't have 3 cases. 2 of which ultimately did not go forward, which is standard in trial practice. 1 of which did go forward, all of which required extensive trial preparations. The undersigned was scheduled to begin a 3-week jury trial in the United States District Court on May 18th. Okay, so not June. The case settled on the eve of trial. Okay. They go on to say that the other attorney was scheduled to begin a multi-week jury trial in the Superior Court in a different case, and that case also was continued at the final trial conference. Lastly, a different attorney was engaged on trial in a different case in the Middlesex Superior Court. The jury returned its verdict yesterday. 3 lawyers, not all 3 had 3 trials. 3 lawyers, 1 trial each, 2 settled, 1 didn't. They say that these existing practice and trial obligations hampered counsel's ability to confer and prepare Mr. Proctor in advance of his June 8th deposition and renders the June 8th date an undue burden. The undersigned was scheduled to begin a 3-week jury trial on May 18th, and the case settled on the eve of trial. So at May 17th? Second, they say, due to personal circumstances, Mr. Proctor has also been unavailable for deposition preparation. The undersigned only became aware of these circumstances recently. Well, it sounds like you haven't been asking your client to prepare. What do you mean you only became aware of the circumstances recently? Or is it that the circumstances only began recently? Question. Counsel for Mr. Proctor will, if the court so desires, provide additional information to the court regarding Mr. Proctor's personal circumstances and the need to reschedule. Footnote 2. As noted above, you need a whole footnote for this. As noted above, Ms. Reed has litigated this matter extensively in the press. See Town of Canton's opposition to defendant's motion to compel, paper number 96.2 at 2, noting, quote, that immediately after the administrative leave letter for the Canton police officer was produced to the defendant, copies of the letter were posted online. First of all, that letter is regarding Sergeant Good. Second of all, anyone that works in connection with that could have done that. Third, what does Sergeant Good's investigation and being put on leave have to do with this at all? And what does this have to do with literally anything? Unless you are saying that the publicity is why Proctor is unavailable for his deposition. Because you can't go into court very well and say, but Your Honor, his feelings are hurt because the press has said mean things to him about his text messages, and so therefore he's unavailable. They footnoted that that is Proctor's personal circumstance. You're just throwing your client right under the bus, saying that the public eyes on his messages are the circumstance. How else are we to interpret that? They go on with point 3, saying the motion should be allowed because Ms. Reed cannot demonstrate any prejudice resulting from the requested relief. And then they cite case law saying that if there's no prejudice, it's allowed. They say, in other words, this is a scheduling dispute, not an outright refusal to produce discovery sought by Ms. Reed. Ms. Reed can show no prejudice based on a short delay in completing one of the 20 depositions Ms. Reed has indicated she intends to take. Moreover, per the Supreme Court docket, the fact discovery deadline in this matter is currently August 17th, 2026. And it sounds like they're pretty booked until that deadline. They say with over 2 months left to complete discovery, the parties should be readily able to identify an agreeable date for this non-party deposition. The problem is, as I see it, if Proctor tries to push his deposition to the end of July, beginning of August, and then fucks around at the deposition, there is not a lot of time for them to go back to court and say he's refusing to answer questions, he's not answering questions, and then to get court involvement, and then to go through more litigation, or say now he's not turning over these documents. They, I can understand, might want time for other litigation if it's necessary regarding Proctor's deposition or the way he answers in deposition, including, which is rare, but it can happen, requesting more time if Proctor takes excessive breaks at deposition and they don't get their full amount of time, or if he walks out or refuses to answer and things like that. There are reasons to not leave this until the very last minute. But they're saying, Your Honor, there's 2 months left. It'll be fine. Conclusion, they say good cause exists to allow the protective order. The disagreement arises from, quote, nothing more than a scheduling dispute. I doubt that. And that there will be no undue prejudice by rescheduling it. And the reason that the court is brought in out of, quote, necessity due to Ms. Reed's refusing to accommodate a scheduling change. Imagine on Friday still being like, we just told them today and they're refusing to accommodate our scheduling request. The audacity. Your Honor, we wouldn't even be here if Reed would just agree to continue this. Right. After the court was yelling at them for not getting depots done. Who could have foreseen that? That doesn't even have anything to do with this being Proctor. The judge very clearly said to all of the attorneys, including Reed's, get it done. Well, let's look at what the court had to say, shall we? On Friday evening, the court responded with an endorsement order, which is, and we've seen this in Massachusetts a lot. We've seen it with handwritten notes on the face of the motion, and we've seen it in typed notes on the face of the motion. So what we're looking at is the court's order late in the day, Friday, in an endorsement order typed in on the face page of the motion. So we're looking at the same motion we just read, and now there is an addendum at the bottom typed in from the judge. June 5th, 2026. Hearing to be held by Zoom on Monday, June 8th, 2026 at 8:45 a.m. by Zoom. Moving party, Proctor, to provide information concerning 1, when counsel learned of witnesses' unavailability, and the court is now calling it unavailability. When counsel learned of witnesses' unavailability for deposition preparation. 2, when Ms. Reed's counsel was informed. Sounds like Friday. But I'd want to know time and method. Was this an email? Was this a phone call? When did Reed's counsel get that information from Proctor's counsel? 3, and this tracks with what the court said last week to attorneys. 3, why deposition preparation could not have taken place today or this weekend. Hey, counsel, I know you think that weekends mean something, but you're a lawyer and you're in a fleet of litigation. You're a defendant in one case, you're a key fact witness in another case, you're the abject of, wrongdoing in a third. Why can't you do it this weekend? 4, supporting witnesses' unavailability as referenced in the last paragraph of page 3 of the motion. This may be filed marked provisionally impounded with a supporting motion if warranted. So what's the court saying there? The reference in the last paragraph of page 3 of the motion says that counsel for Mr. Proctor will, if the court so desires, provide additional information to the court regarding Proctor's personal circumstances and need to reschedule. And then it footnotes, Karen Reed has litigated this matter in the press. The court wants to know why. What are you talking about? What are these personal circumstances? Literally, tell me why. And then the court says, all filings due by 5 p.m. on Sunday. Copies shall also be emailed. And then he gives the judicial assistant's email. And on the docket today, as I'm recording this on Sunday, There are no updated docketing items. However, I don't expect that we will see those because I don't believe they are automatically docketed. I believe that the clerks have to docket those, and we will not see those until Monday. I intend to attend the Zoom hearing very early in the morning to take notes and let you guys know. I do not know if they will allow the media to record it. I do not know if they will impound part of that Zoom call where there is no media presence because the court's provisionally allowing it to be impounded or sealed, what the personal circumstances are. And so I am going to be very interested to share with you what I learned from this hearing. And then if any media has the ability to record it, we will go over it together probably on Tuesday, but I will keep you updated in the Law Nerd app. And hopefully going over the background of what's happening here has given some helpful context to why it seems ridiculous that at the 11th hour before this deposition, all of a sudden counsel's like, hey, but we had some trials scheduled. That trial settled in May. And also now my client was unavailable to prepare. Well, I guess we'll find out more about what those circumstances are and if Proctor is ordered to complete his deposition on Monday. On Monday, I can see the court perhaps saying, okay, do it on Tuesday. But from what we heard from the court during the last hearing was that the attorneys had depositions set back to back to back to back. And when you are scheduling things with lawyers, it's not just the schedule of Proctor's lawyer and Karen Reed's lawyer. The other attorneys for all the other parties have a right to be present and participate in that deposition. So now you are talking about lawyers for all the parties, lawyers from the Waterfall, lawyers from CF McCarthy's, lawyers from the plaintiffs, in this case, the O'Keefe's, Reed's lawyers, and Proctor's lawyers. You are dealing with 5 separate sets of lawyers. That is a scheduling nightmare to try to pick another date that works for everybody. So I am very interested to how this continues to play out. And if the court is going to say, no, go to your deposition. What's it scheduled for, 10 a.m.? Go to your depo. We'll see what the court does. And then the next question will be, Emily, what happens if Proctor no-shows a depo? Great question. We saw this in the Corey Richins civil cases not that long ago, where we went over the fact that the court awarded all of the attorney's fees and costs for the no-showing the depo, and it ended up being upwards of $10,000 for all the cases where Corey Richins no-showed a depo without notice. Yes, there's notice here, but if the court orders it, not only no-showing after a court order could be contemptible and sanctionable, but also the court can then order the party to pay attorney's fees for costs of the court reporter who is going to need to record it, whoever is being paid to record it via video, not just by court reporting, the time of lawyers if they had to travel, the billable hours for the preparation for the deposition, because that is a part of it as well. So there are some consequences if someone just no-shows a depo. If the court continues it, I would be interested if the court also gave some acknowledgement of costs, knowing that we've already had lawyers travel from California to Massachusetts for this deposition. And that might be the same for other attorneys on Karen Reed's team as well. And all the time they took to prepare that deposition as well. So what happens next? We're going to have to wait and find out. Make sure you have the Law Nerd app at lawnerdapp.com. And I can't believe this case is still having such unexpected changes at the last minute. But is it really that unexpected? Didn't we all talk about it together on Thursday when I said, I wonder if Proctor will try to wiggle out of this deposition? Well, he's trying to do the wobble, and we'll see what the judge decides. So thank you for being here. Thank you for being a Law Nerd. Stay tuned in the app, and I'm sure we'll be talking about this more during stream on Tuesday, but I can't wait to see what happens with this one. All right, I'll see you soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here. and thank you for being a law nerd.